Start by saying that I don't normally sound like this. This is my very white face due to a slight cold, but I will try to make myself heard anyway. So as I said, I'm part of the philosophical side of this project, together with my esteemed colleague, Christian Munthe over there. And we are working mostly of the conceptual and moral aspects of hate crime. And this is what I think we can bring to the table here. So, when I do presentations of hate crime and my work and our work on hate crime, I often get the question at the beginning, what on earth is a philosopher doing in this project, and why should anyone listen to a philosopher? And I will try to explain why you might want to listen to a philosopher in this context, and that you shouldn't listen only to philosophers, but you should listen to a project where philosophers are part of the work, at least. So why are philosophical perspective and philosophical considerations relevant to hate crime scholarship? Well, there is a connection between having a legitimate concept and a legitimate law and practice. If we haven't worked through the justification of a hate crime law sufficiently well, it won't be used. It will lead to failures of implementation. It will lead to a situation which is very much like a situation we have now in Sweden, that judges seem to be very reluctant to use the hate crime rules. The police officers are very unclear about what the hate crime is and how to report it, when to call something a hate crime. And monitoring is flawed. There is a very good survey each year in Sweden registering the number of hate crimes, but there are a lot of problems with this, because we don't know how many of these reported hate crimes actually are hate crimes, and there's a lot of confusion surrounding with victims, with police officers, and with attorneys and with judges, what hate crime is supposed to cover. And this means that it's very difficult to make proper research and to collect proper data in this area. And this is one of the most ambitious goals of this project, or what will happen after this project, to actually help remedy this situation. So what's needed, and what I think we can try to help with, is a clear view of the hate crime concept, what it involves, and also its moral foundations, the justification of this hate crime law and of the hate crime concept. So that's what I'm trying to do here today. Right, so if the hate crime concept is related to certain functions. The concept has functions, and the concept is defined by the function it serves. So we have a basic concept that seems to be the concept that most people get when they talk about hate crime. That is that a hate crime is a crime, an ordinary crime, that's committed with a hate or bias motive. So it seems to be a type of crime individuated by the motive. And this concept is supposed to serve a number of functions. We have functions that has to do with the criminal law. We have to have a law that says that hate crimes should have this type of punishment, and it's against the law, and so on. And very often, in most legislations, hate crime is associated with punishment enhancement. That is, if your crime is not only a crime but a hate crime, you will have a stiffer penalty. So we need a concept that can deliver that. Then we have the function of monitoring. We need to enable reliable and ideally comparable statistics. And that's one of the reasons why we want to have a common hate crime concept for the EU countries. So we can compare statistics between the countries and see what sort of measures work, what sort of policies has an impact on the frequency of hate crimes. And then we have the prevention idea. We want to prevent hate crime, of course. And then we need a concept of what it is that we want to prevent. So these are a few of the functions. Maybe there are others. But here are some of the central functions of a hate crime concept. There's a possibility that there's a different hate crime concept for each of these functions. And that is, of course, very awkward. And it might also be counterproductive, because what happens in the criminal law is part of the project to monitor the frequency of hate crime, for instance. We would like it would be ideal if we had one concept that is usable in all these contexts, but it might be problematic. It might be that a good legal hate crime concept has one formulation, and a good policy enabling concept has another definition. We need to be clear if that is the case. And I should also say that if we are to have a unified hate crime policy, at the national level and at the EU level, it should cover all of these functions, because all of these functions are relevant to policy. All right. So take up a number of considerations. The moral considerations, the legal considerations, and the political considerations. First of all, I'm a moral philosopher, and so is Christian, so moral considerations are, of course, what we like to do. So here are a number of moral considerations that are relevant to hate crime. First, we have the issue of harm. It's often stated that hate crimes hurt more, that being the victim of hate crime is somehow worse than being the victim of another type of crime. And this harm, the harm that's caused by hate crime, it's a harm that falls to the victim, to the group that's targeted, and also possibly to the society, because hate crime seems to make society worse in a way. It worsens relations between groups, for instance. And harm is traditionally a very important part of moral philosophy. And a lot of moral theory says that we should avoid harm, and we should try to make people happier. So harm is, of course, an uncontroversial central moral feature. So if hate crime hurts more, then of course it's morally relevant here. The second idea is the idea of intention, that hate crimes may be performed with the intention, not just to hurt this individual, to assault this individual, but to threaten and to harm the group to which this individual belongs. And that, of course, is a moral consideration. That if your intention was not just to harm one individual, but to harm a large set of individuals, then you are more culpable. The third consideration has to do with motive. That hate or bias or prejudice in itself might be worse than other motives. So this is another set of traditions in moral philosophy that points to this type of consideration, and that might be relevant. We might say that a prejudiced person is actually a bad person in some sense, and this is a bad value to have. We have ideas surrounding character, that you're somehow flawed as a human being if you're prejudiced, and hate crimes exhibit this flaw in some sense. Then we have the idea of the content of a crime. That if you perform a hate crime, you express a certain view, a wrongful negative evaluation of a group. And that's what's morally problematic. So this is what's included in hate speech laws, for instance. The last consideration, which is my favorite, by the way, has to do with reasons. And this is what I'm basically working on when I try to do not just general presentations, but something that's a positive contribution to this debate, is that a hate crime involves acting for a bad reason. That is, it's not just that you have a bad motive, it's that you treat that motive as a reason to act. And because that's something that's subject of a decision on your side, to treat something as a reason, you can be held responsible for it. So that's actually slightly different from point 3 here, the motive. So here's a number of moral considerations that are brought into the hate crime context from a philosopher's point of view. Then we have the legal considerations, because there is a problem. Even if we agree that there is such a thing, that hate crime is somehow worse than other crimes. And it's uncontroversial that it's worse, because it fits one of the criteria I just mentioned. And we might also agree that having a hate crime law might actually help. It might prevent a lot of crimes from happening. Are we justified in enhancing punishment for these crimes? Because it seems that we're not allowed to punish all moral failings, only some of them. So there are some restrictions that apply in the criminal law context. So we have to have a law that's actually legitimate, because there are certain limits to criminal law. The question is whether hate crime, however we define it, falls within those limits, or if it goes outside it. Okay. So there are certain restrictions that apply, that has to do with whether the criminal is responsible for the feature that we are enhancing punishment for. So are we responsible for our motives, for instance? Are we responsible for our intentions? And this, of course, speaks to culpability issues. So there is this view that the law does or should not judge attitudes and thoughts and values. And it seems like a hate crime law does this. If hate crime just is a sort of crime that's committed while you have a certain attitude, it seems like the punishment added is actually punishment for this thought or attitude. And that seems to be a problem, at least for a liberal conception of the criminal law. We do, however, recognize that motives may be mitigating factors. Sometimes the sort of explanation or the sort of reason why I commit a crime, say to feed my family or something like that, is a mitigating factor. So we already agree that motives may be relevant to punishment, but it requires further justification to add punishment than it does to subtract punishment. So that's an important issue. So if we are introducing a new kind of punishment for motive that hasn't existed before, then we need a lot of justification for that. And it might be controversial. And this controversy might be part of why judges are so reluctant to apply this law. There is also the suggestion that the aggravating features of hate crimes is actually already covered by other laws. I don't mention it here, but if the reason why hate crime is worse and should be punished more than other crime is that it hurts more, then we already have laws that cover that, because the extent of the harm is relevant to punishment already. So then you already punish crimes that have this tendency to do more harm. There's also the idea that hate crime is actually an example of discrimination. This is inherent to the victim selection model of hate crime, for instance. And that's actually why you deserve a harder punishment, because you're not discriminating between victims and using someone's disability or someone's group membership as a basis for a crime, and that's what you should be convicted for. There's also the idea that hate crime is a species of terrorism. That is, you have a specific intention when you perform this crime, not only to hurt this person, but to harm the group. And that sort of intention is something we very well may punish for. We can also say that hate crime is defamation or something of that nature. That is, hate crime involves an act of hate speech. And that's added, there's an extra crime involved. It's not that the crime itself is worse and should be punished worse, but there are two crimes involved. So there are some legal considerations. Here's some other. Laws have functions, so the criminal law has a set of functions, and there is a lot of types of theories about how to justify laws. So what do we want from a hate crime law or a statute, and what do we want from a hate crime law enhancing punishment for these crimes? Well, one idea is that we should justify a law by retribution. We are avenging in some way, we are providing retribution for the greater wrongdoing involved in hate crime. The second point has to do with reparation. There is a specific or a greater harm involved, and we need to repair that in some sense. And that's why we are justified in enhancing punishment for hate crimes. We have, of course, prevention. We try to stop these crimes from happening for a lot of reasons. Partly by detaining the criminal, so he or she do not commit any more crimes during the time they're in jail, or not of this kind anyway. But more importantly, to deter other people from committing this sort of crime. So that's one of the functions of criminal law, to deter people from committing crimes. We have rehabilitation, that is, we try to make the hate offender less likely to commit crimes in the future. So that's a function that we believe, at least, that the criminal law is set to serve. We have support for victims and for targeted groups. That is, we need to show that we take their situation seriously. So that's one function of having a law of this kind. But we also have the idea that a law expresses a value in society. In the case of hate crime, it expresses values like toleration or equality or something like that. So these are all functions that the criminal law serves, and these are all functions that might be served by a hate crime law. So these are the considerations that applies to hate crime. Next, I'm moving very quickly here. Next we come to the political considerations. Because it's possible that the specific problem with hate crime, that's not just the problem with crime in general, might be something that the law isn't very good at addressing. But it can be addressed by policy measures. There are other types of things that we can do to prevent and show support to these groups and express the value in society. So there might be other measures that are more justified and that are more effective as well than having a hate crime law and adding punishment for these crimes. So it might be that what's special with hate crime as opposed to the base crime is a problem for communities and for a society. It's not a problem for individual victims or even for specific groups. Usually the criminal law is engaged with issues that have to do with one perpetrator attacking one victim. But the problem with hate crime seems to be at another level. It seems to be at a more structural level. It's a problem with prejudice in society, and it's a problem with the state of fear that's being induced in that society and in certain groups. And that might actually be something that we should address by policy measures and not by legal measures. Or that legal measures should only be part of this and not even the most important part. So we need to be able to have a concept that enables monitoring in some way. We need to track and address the causes of crime, of course. If we find that hate motive is very common, then of course we have to reduce hate motive. We have to work against prejudice to get at the root cause of hate crime. But that's not being said that by that we're not saying that we need to punish causes. Maybe we shouldn't punish causes. We should work against causes of crime, but maybe we shouldn't punish them. For instance, if we're not responsible for the causes, we should not punish them, but we should of course work against them. For instance, if crimes that are being committed at night is more frequent than crimes being committed at day, we need to do something about night crime, and that doesn't mean enhancing punishment for crimes committed at night, but other type of measures. Okay. One suggestion of how to do this is that rather than expressing a societal value of toleration and equality by enhancing punishment, you make hate crime a priority. That is, you say to the police that you should put this at the top of your work pile. If you have a hate crime, that should take priority over other cases you're working on at the moment. And that might actually be more effective because, as it is, hate crimes are likely to go to the bottom of the pile in a lot of countries. Unfortunately, because they are difficult to deal with. And making hate crime a priority is not subject to the same sort of restrictions. You don't have to justify it in the same way. An offender can't complain that he or she is being unfairly treated by the justice systems if the type of crime she's committing has been prioritized, in a way that she can complain of punishment enhancement, for instance. So that's a reason why we might want to favor that sort of approach rather than punishment enhancement. But there are problems with this approach too, of course. For instance, it seems to be dependent on political fluctuations. Priority, in Sweden at least, is decided on a yearly basis. And that means if hate crime becomes unpopular during one year, it won't be a priority anymore. And of course, a law or a statute will be more permanent than that. So there are conflicting considerations there. It's of course important to target the causes of crime before it becomes a cause of crime, so to stop this causal chain in some way. So we should probably target prejudice at an early stage. So the work against hate crime is only part of this very larger, more important project. It actually has to do with the problems that are being caused by prejudices in society overall. It's not only that these prejudices causes crimes and harm to arise, it also that it makes certain exchanges in society less likely, and it's actually an economical cost that people have prejudices against each other. And that's a larger project that's not has to do with hate crime specifically, but hate crime is part of that project. The thing is that the hate crime concept used in this context, in the policy context, probably should include motive. Because motive is, as I said, the cause of these crimes, and we need to target the cause of these crimes. So motive is an explanatory part, and it seems to be an essential part of hate crime in this sense. So if we want to avoid motive in the legal setting, we might still want to include it in this setting. And that, of course, is the tension in this field, as I see it. So here are 4 hate crime concepts that I have looked at a bit. We can have the classic hate crime concept that just say that a hate crime is a crime that is motivated or caused by hate or prejudice or bias. So that includes motive in a central capacity. The second concept describes hate crimes as specific intent crimes. It's a sort of crime that you do with the intention to harm the individual in a specific way, but also the individual's group in some specific way. And then motive is not relevant, because you can have this intention to harm a group without hating that group. You might have some other motive. And if that's still a hate crime, it should still be subject to the same laws, and it should be punished in the same way. But motive is no longer relevant, so that might be preferable if we don't want motive to enter into the picture in the legal setting. We can also try to identify hate crime by the specific kind of harm that's being caused by hate crimes. The harm that's being done to primary victims, to secondary victims, and to tertiary victims. That is to the victim of the crime, to the group, and to society as a whole. So there may be distress in the individual victim, or death in the individual victim. There's fear in the group, and then there is societal unrest at the tertiary level. This is more difficult because it seems that hate crime have different type of consequences. It's very hard to define a type of crime on the expected consequences in this way. And then we have the fourth concept that say that we have a crime which involves hate expression, or which have hate content. That is, in addition to the crime, we have a hate speech crime, or hate speech on top of the crime already. And that, of course, if we agree that hate speech laws are justified, then we have no problem with justifying this sort of construction for hate crime. So here are four different versions, and it seems like these four different versions are consistent with different countries' legislation as it looks right now. In the Swedish statute against hate crime doesn't mention hate crime, but there is a statute that enhances punishment for prejudiced reasons. In a way, there is a great uncertainty if it's number one or number two that's actually being counted. There's a confusion of intention and motive in Swedish legislation. I think it exists elsewhere as well. And some countries may have laws that looks more like 2 or 4 than the others. But we need to make up our minds here and to know what we are talking about. What type of these, which of these concepts is actually active in our setting. The concepts have variables that we need to decide on. First, we need to decide what sort of crime, what type of crime can be a hate crime. Is it all crimes, or is it just assault? And this varies between the countries. Also, the type of attitude. What type of attitude is hate or is prejudice? Are we targeting a disposition or an emotional state? We need to make up our minds on that score. And the third point has to do with victims. What is a victim of a hate crime? Can it be someone belonging to just any group, or is it just specific groups that can be target of hate crimes? And that's where the great variability is between the EU countries, for instance. So what we need here is some criteria for inclusion here. Either we say that it can be any type of group, so as long as you have this motivation, or your reason for committing a crime was that the victim belongs to this group, it doesn't matter what the group. Or we have to develop some criteria for inclusion. And this may have to do with whether the group is vulnerable in some way, whether there's a history of harassment, if the feature that they're being targeted for is immutable, or just if they're being frequently targeted. If we have the last criteria, then we have the possibility to actually add new categories if that category becomes a more likely target of crimes, for instance. And of course, then we have the relations between these variables, the relation between the type of crime and the type of attitude being committed. So a hate crime, if we include these variables, is a crime with variables within one, that is, we haven't determined what type of crime, committed with, that is, there is a relation between the attitude and the crime, a certain attitude, and we need to determine what attitude that is, and towards a certain group, and we need to determine what groups that may be. We have criteria for those groups at least. So this is a hate crime concept when we are undecisive. That's how it looks. A relevant question here is how much variation can we actually allow, so to speak, between the different countries, yet gain from comparisons and having a common policy? Can we just say that this is the concept we use, and then the individual countries can make up their mind on their own what sort of relation holds between attitude and crime, and what groups are being the target? Or do we need to be more specific, even on this common concept level? So that's a big problem. It seems that some variability is essential for comparability. Because we want, if there are different groups being targeted by hate-motivated offenders in different countries, we need to take that into account when we compare statistics. What's important is how many hate crimes are being committed, not specifically how many hate crimes against Muslims or gay people or the Sami in Sweden, for instance. The important thing for comparability is whether the groups that are actually targeted is being more targeted due to some circumstances. So that's the kind of thing we want to compare, I believe. Okay, last slide here then. What we're proposing is a conceptual framework for hate crime. So that's what I think that we can provide. So we need a concept. We have some variables that might be determined due to context. In particular, the variable about what type of group may be the target of a hate crime. So that might be sensitive to what groups are being targeted in that particular country. And this sort of framework need to encompass the morally relevant factors in these crimes. For instance, a hate crime seems to be a crime that involves a specific intention or acting for bad reasons, and that is evidenced by the content, for instance. And this content provides some proof of motive. So all these factors are involved in the general conceptual framework here. And these type of acts are likely to cause additional distress in the victim and in the victim's group. So if we have that sort of framework, then we have all the features mentioned in the moral considerations. But the key question is still, is motive targeted or is it directly relevant? It need not be, and in fact there might be reasons not to include it in the legal concept. If it leads that it's unlikely to be used, and if it leads to issues making certain politicians and certain governments unlikely to prioritize this sort of crime, we can actually strike motive, because motive isn't essential to have a hate crime concept. There are other possibilities, and that might be preferable if it's more effective. But if we are to have a concept that's useful in the policy making and in monitoring and in actually addressing the causes of crime, then that sort of concept, in that sort of concept, the motive actually seems to be directly relevant. So we might not want to exclude it from that concept in that concept. Of course, ideally we would have a single concept. And the reason why we would have a single concept in all settings is that the police and court data could be gainfully used in the other functions, in monitoring and evaluating policies, for instance. So that might be reasons to have a single concept and actually settle on one of these and be very clear about which of these concepts we are using. So we have a dilemma here. The various functions may favor different concepts. So a concept that's useful in policy setting might not be useful in a legal setting in the same way. So the very not very informational conclusion of this is that a conceptual framework of the sort proposed here, that actually lists all the factors that might be relevant and might be included, is a useful place to start with this work, even if it hasn't thereby introduced a concept that we can apply throughout the EU. So that's how I end this. Thank you.